Welcome back to Talk Testimonies.
Always a pleasure to be back.
You know, we really try to cut through the complexities of Supreme Court arguments and bring you the insights that you really need to know.
That's right.
Today, we're going to tackle Paloma Gaos, also known as Gaos versus Google LLC.
Right. Big case.
And we're going to start with the core of it, you know, what was actually argued before the justices.
Right.
And then unpack some of those key questions that arose during that session.
Absolutely.
So I guess the place to start is really to give us a little background on this. So what's the case all about? What happened here?
Well, so the Supreme Court heard arguments in this case, Paloma Gaos v. Google, on October 31st, 2018.
Okay.
And this stemmed from a class action lawsuit
Yep.
Alleging that Google improperly disclosed search terms through something called referrer headers.
No.
And it's important to note the court didn't issue a final decision on the actual merits of the case at this stage. Instead, the arguments largely focus on whether the plaintiffs, the people bringing the suit, had the legal right to even bring the case. That's the issue of standing.
Okay, so whether or not they had a right to even sue Google in the first place.
Exactly. And whether the proposed settlement, which primarily directed funds to third-party organizations, was appropriate.
Okay, so let me just make sure I understand this.
Okay.
So before even getting into whether Google did anything wrong, the court had to consider whether the people suing them even had a legitimate reason to be in court in the first place.
That's right.
And the proposed fix, the settlement, wasn't your typical, everyone gets a check scenario.
Exactly. And the justices really spent a significant amount of time questioning whether the district court had the authority to approve the settlement, given these potential problems with standing. And they scrutinized whether using a CPERS distribution, where $5.3 million would go to groups like AARP and the World Privacy Forum, instead of direct payments to potentially over 100 million class members, met the legal standard of being fair, reasonable, and adequate under Rule 23 of the Federal Rules of Civil Procedure.
Oh, wow.
So ultimately, no decision was announced during this argument.
Oh, wow.
The possibility of sending the case back to lower courts for further review or even dismissing it was discussed.
Okay, so even just based on what you said so far, it sounds like a lot of pretty complex legal issues at play here.
Yeah.
So let's try to break this down piece by piece. You mentioned standing.
Right.
That seemed to be like the foundational question here.
Yeah.
So what exactly were the justices grappling with?
So the argument kicked off with whether the lead plaintiff, a guy named Anthony Talleyano, had demonstrated what the law calls a concrete and particularized injury.
Okay.
In simpler terms, did he experience a real harm that was specific to him? The concern was whether the disclosure of his search terms, which might have included his name, home address, which is information often publicly available anyway, and things like bankruptcy or foreclosure records, which again are frequently public records, truly constituted a privacy violation significant enough to warrant a lawsuit in federal court.
So the argument being that the information being disclosed might not have been all that private to begin with.
Right, that was a central point. Lawyers for the plaintiffs, though, raised what they called the re-identification theory. The idea that even if individual pieces of data seem public, website operators could combine referrer header data with other information to identify individuals and their specific searches, potentially revealing sensitive details. So some of the justices seemed skeptical of how likely or significant this chain of events would be.
So it's that idea of like piecing together a puzzle.
Right.
Individually, the pieces might not reveal much, but together you can see the full picture.
Exactly.
But how many pieces and how much connecting is too speculative for a legal injury.
Precisely. And the court also considered whether the violation of a legal right created by Congress, in this instance, under the Stored Communications Act, could establish standing even without a traditional, common law type of injury. And interestingly, when asked about a previous Supreme Court case called Spokio v. Robbins that touched on this, the government's representative chose not to take a position.
The government staying neutral on a point that seems pretty key to the whole case.
Right.
That definitely suggests some uncertainty there.
And I think it highlights the difficulty of applying older legal concepts to the complexities of, modern technology and data privacy.
Right.
Justice Kavanaugh even posed a question, likely resonated with many people. Wouldn't most individuals consider their search history private information and its disclosure an injury? Yet the level of specificity of the disclosed information and the fact that some of it might be publicly accessible, remained a sticking point for several justices.
Right. So even if somebody feels like their privacy was violated, the legal standard for a concrete injury might be a tougher hurdle to clear.
Right.
It's not just about feeling wronged, is it?
No.
So what exactly were the justices looking at in this specific case to determine whether that threshold was met?
Well, they were looking for tangible harm, not just a hypothetical or speculative injury.
I gotcha.
And, the argument for Mr. Talleyano's injury, as his counsel acknowledged, was, potentially not the strongest.
Okay.
And that may explain why the overall settlement amount was relatively small compared to potential statutory damages. But they maintained that the disclosure itself constituted a concrete violation of his rights under the Stored Communications Act.
Okay.
So, the possibility of sending the case back to the Ninth Circuit Court of Appeals to re-examine the standing issue in light of existing Supreme Court precedent was also a significant part of the discussion.
So it sounds like the justices spent a good chunk of time on whether there was even a valid case to begin with.
Yeah.
But now let's turn to the proposed solution, the scrutinized press settlement.
Yeah.
Now, for those of us, not fluent in legalese, can you break down what that means and why it was a point of contention here?
Certainly. So CC press settlement is it's when funds from a class action settlement aren't directly distributed to the class members, often because doing so would be impractical or the individual payouts would be too small to justify the effort.
Okay.
So instead, the money is given to nonprofit organizations that are deemed to serve the interests of the class or the public good.
Okay.
So in this case, the proposal was to give $5.3 million to groups like AARP and the World Privacy Forum with no direct monetary relief for the potentially over 100 million Google users who were part of the class action.
Wow.
And, a major concern raised was whether the lawyers representing the class counsel, might have a conflict of interest. The worry is that they might prioritize CC Press awards, which can be easier to arrange over the, more challenging task of trying to directly compensate a massive number of individuals. Right.
Right, because I guess from a lawyer's perspective, it's much easier to just write one big check than to try to figure out how to divide up money among, 100 million people.
That's exactly right.
But it does bring up the question, though, of who the settlement is really benefiting, doesn't it?
Yeah.
Is it primarily about compensating the people who are allegedly harmed, or is it more about the lawyers getting paid and then directing funds to, organizations they might favor?
That's precisely the tension at the heart of the debate.
Okay.
And the feasibility of directly distributing funds was discussed. Google's lawyers, they mentioned that, the potential payout per class member could be as low as 67 cents.
67 cents. You probably lose that in your couch cushions.
Right.
So in those kinds of situations, the idea of RC Press makes a certain practical sense.
Yeah.
But it sounds like the justices had some, serious questions about how these recipient organizations were chosen.
Absolutely. Concerns were raised about the criteria used to select these CC Press beneficiaries. Were these organizations truly aligned with the specific privacy concerns raised in the lawsuit? Were there any connections between these organizations and the law firms involved in the case, or even with Google itself, through past donations or collaborations?
Oh, wow.
And the Ninth Circuit Court of Appeals, which had initially approved the settlement, uses a standard where CC Press is acceptable if the individual payouts would be de minimis, meaning very small.
Okay.
However, other federal appeals courts take a different approach, emphasizing a closer nexus or connection between the recipient organizations and the harm suffered by the class. They argue that the money should, as much as possible, benefit those who are actually affected by the alleged wrongdoing or organizations that directly address that specific type of harm.
So it sounds like the money should ideally go to groups that are working on the same kind of issues that the lawsuit was about.
Right.
Were the justices convinced that organizations like AARP and the World Privacy Forum met that criteria in this case?
That was a key point of contention. For example, Justice Sotomayor questioned whether AARP's focus on online fraud was directly relevant to a case about the disclosure of search terms.
Right.
While both relate to online activity, they aren't exactly the same. And the justices explored whether there was a sufficiently direct link between the alleged privacy harm and the work being done by the proposed recipients.
Makes sense.
And, alternative solutions like holding a lottery among class members for, a larger share of the settlement funds were briefly mentioned but quickly dismissed as still facing the challenge of identifying and notifying such a vast class.
So it's really a tightrope walk between trying to achieve some form of justice for a huge number of people, and the practical limitations of doing so, especially when the individual harm might seem relatively minor.
Right.
67 cents is not a whole lot of money.
It's not a lot.
So finally, it sounds like the justices also touched on who should be setting the rules for these kinds of settlements moving forward. What were their thoughts on that?
Yeah, that's right. They question whether the detailed guidelines for class action settlements, particularly concerning the use of superpress, should be primarily developed by the courts through their interpretation of Rule 23E of the Federal Rules of Civil Procedure.
Okay.
Or whether Congress or the advisory committees responsible for drafting these rules should provide more specific direction.
Okay.
The argument was made that the term reasonable in Rule 23E gives courts some inherent flexibility to adapt standards over time based on legal precedent and common law principles.
Gotcha.
However, there was also a suggestion from the government's representative that clearer statutory guidance from Congress on the appropriate use of superpress in class actions would be helpful to provide more certainty and uniformity across the different courts.
There's kind of a debate about, who has the authority and the expertise to really nail down what's fair in these really complex situations.
Exactly.
Well, this is the part of the show where we put on our imaginary robes and step into the 10th chair.
I love this part.
So if you were sitting on the Supreme Court, during these arguments, listening to all of this unfold, what would be your key takeaways? What's your overall assessment of the issues presented in this case?
Stepping into that 10th chair, a central tension in this case, to me, strikes me as the struggle to balance, the principles of individual redress with the practical realities of mass litigation in the digital age.
Okay.
While the ideal is always to directly compensate those who have been harmed, the administrative hurdles and costs in cases involving hundreds of millions of potential class members can quickly become overwhelming,
right,
often leading to individual payouts that are so minimal, they offer little real benefit.
It's almost a situation where the effort outweighs the reward for the individuals.
Precisely. However, the questions raised about standing are fundamental.
Right.
The requirement of a concrete and particularized injury is there for a reason, to ensure that federal courts are addressing actual cases and controversies. And, the argument that the disclosure of search terms, some of which may be publicly available, constitutes a sufficient injury in this context, feels, somewhat tenuous. If the threshold for standing is lowered too much in the digital realm, it could potentially open the floodgates to a vast number of class action lawsuits based on fairly abstract harms.
That could have huge implications for businesses and the legal system as a whole.
Absolutely.
Wow.
And turning to the SUSI settlement, while it can be a useful tool in situations where direct distribution is genuinely infeasible, the process for selecting beneficiary organizations demands rigorous scrutiny and transparency.
Okay.
And the appearance of, any potential connections between the settling parties and the recipients raises legitimate concerns about whether the interests of the class are truly being prioritized. The focus should always be on ensuring a strong nexus between the work of the SUSI Press recipients and the specific harm alleged in the lawsuit.
Yeah.
Funding general public interest initiatives, however worthy, should not come at the expense of a genuine effort to provide some form of meaningful benefit to the class members, even if that benefit is not a direct monetary payment.
So even with press, the link between the harm and the remedy is crucial.
Exactly. Ultimately, this case highlights the ongoing challenge of adapting established legal frameworks to, the unique complexities of our increasingly digital world. It underscores the need for a principled approach that seeks to provide meaningful accountability and redress, while also acknowledging the practical limitations of class action litigation in the face of massive data and widespread, yet sometimes individually minor, potential harms. Finding that balance is the key.
His deep dive into the arguments in Paloma Gaos et al. V. Google LLC certainly gives us a lot to consider about the intricacies of Supreme Court proceedings, in particular when dealing with class actions in the digital age and this often debated practice of sortie process settlements. Hopefully this breakdown has given you a clearer understanding of the core legal questions at stake and the different perspectives that were presented to the justices. This case really illustrates the evolving legal landscape surrounding privacy in our increasingly digital lives. What are your thoughts on the balance between, individual rights and the practicalities of large-scale litigation in this digital age? Leave us a comment and join the conversation.